Hello everyone and welcome to this video tutorial in which we're going to be doing some A-level law revision on the topic of vicarious liability in tort. And vicarious liability is the term used to explain the liability of one person for the torts committed by another, and it mostly arises in employment when an employer might be liable for the torts of his employee. So if you want a quick refresher on this area of law, keep watching. So as I've just said, vicarious liability is a tort where our defendant is found to be responsible for the torts of another person. Now, straight away, that sounds like it's very harsh, it's very unfair. Why on earth would we have such a rule? You might be thinking to yourself. So to answer that, I've included a quote here from Lord Nichols in the case of Dubai Aluminium from 2002. And Lord Nichols sort of explains quite eloquently, really, why we have vicarious liability. So he says, quote, "The underlying legal policy is based on the recognition that carrying on a business enterprise necessarily involves risk to others. It involves the risk that others will be harmed by wrongful acts committed by the agents through whom the business is carried on. When those risks ripen into loss, it is just that the business should be responsible for compensating the person who has been wronged." So what Lord Nichols is saying there is that just as the employer is getting the benefits, he's making a profit out of his employees, he should also be prepared to bear the costs of those employees' mistakes and torts when carried out in the course of their employment. And of course, there's also the practical reason that, generally speaking, the employer is going to be in a better position than the employee to give the compensation or the damages to the claimant. And indeed, they might have insurance specifically for that. So in order to apply the law on vicarious liability, I've summarised the key steps here into these 3 points. So firstly, a tort needs to have been committed, and I've put negligence in brackets there because usually, and certainly in your exam scenarios, it's probably going to be negligence that's occurred. So there has to have been a tort, and this tort must have been carried out by an employee, and the term employee is going to be very important here. And finally, we must be sure that it was done during the course of their employment. And again, this phrase, course of their employment, is very important when we're applying the law on this. So the first thing to ask ourselves is, was the tortfeasor an employee? Now I've got this unusual word tortfeasor here, and it's a very old-fashioned word, it sounds a bit strange, but the reason I've not got D or defendant here is that you need to remember that when you're applying the law on vicarious liability, the defendant is going to be the employer, and the tortfeasor, that means the person who did the tort, who committed the tort, were they an employee? So we're using tortfeasor here to distinguish that our potential employee is not actually the defendant, but they are the person that seemed to have committed the tort. So to decide who is an employee, we need to look at a number of different tests that the courts have established to try and determine whether a person is an employee or not. And over the years, this has actually become more difficult as contracts of employment have changed, and it has become quite difficult sometimes to determine whether a person is technically an employee or they're an independent contractor. And if you've watched my other videos on vicarious liability, you'll perhaps be thinking of the Uber case on that. So that's an interesting one to have a look at. But our key cases for revision purposes, we'll start here with the control test. So the control test, came from the ancient case of Ewing and Noakes, 1880. And this test considers whether the employer has the power to control the nature of work done and how it is done. And it's an old test that uses the concept of the master-servant relationship. And that's why we've got this image here of an employer being a bit of a puppet master with his employees. So you can see he's got control over the actions of his employees there. The next test that we've got is the integration test, or it's sometimes called the organisation test. And this distinguishes between people who sign contracts of service and those who contract to provide services. And essentially it looks at how integrated the person is into the actual business. And I've got a quote from Lord Denning here from the case of Stevenson, Jordan and Harrison and MacDonald and Evans. And in that particular case, Denning said, "One feature which seems to run through the instances is that under a contract of service, a man is employed as part of the business, whereas under a contract for services, his work, although done for the business, is not integrated into it, but is only an accessory to it." We also have the multiple test, or it's sometimes called the economic reality test, and this comes from the case of Ready Mix Concrete and the Minister of Pensions. And in this particular case, it was held that the drivers in the particular case were not employees, and they came up with 3 criteria which had to be met before an employee status was granted. So it's almost like a checklist, a multiple stage check. Firstly, the individual must provide work or skill for the employer in return for payment or other remuneration. Secondly, the individual must have agreed either expressly or impliedly that they will work under the control of the employer. And thirdly, the other circumstances of the individual's working agreements must be consistent with those of an employee. And then finally, we've got this really interesting case of Cox and the Ministry of Justice. And this arguably has opened up the relationship much, much wider than it's ever been with the sufficiently close connection test. And in this particular case, it was held that the question really was whether the employee's tort was so closely connected with his employment that it would be just to hold the employer liable. And if you recall the facts of this particular case, in Cox, the claimant worked in a prison as a catering manager, and he was injured when a prisoner who was employed to work in the canteen accidentally dropped a sack of rice on her back, and the question arose as to whether a prisoner carrying out work in a prison satisfied this employer-employee relationship. And in the lead judgment, Lord Reid said that the finding was that there was close connection and it was fair, just and reasonable to impose vicarious liability on the employer. So we've got a number of different tests to use to determine whether someone was an employee or not. And whenever you've got lots of tests in law, of course, that makes the law more complicated. You're likely to get lots of perhaps inconsistent decisions. And the fact that the law's opened up so broadly here with that close connection test is arguably quite harsh on employers. So that's something to think about if you get an evaluative essay on this area of law. And we're on to the final stage here. So step 1, we've decided that there was a tort. Step 2, we've worked out that the tortfeasor was an employee using the various tests. The final stage is checking whether the tort was committed during the course of employment, because an employer is not responsible for a tort committed by an employee outside of the course of employment. So first off, let's start by considering this interesting phrase here. An employer won't be liable for an employee if they've done something when they were on a, quote, frolic of his own. And this comes from the ancient case of Story and Ashton. And in that particular case, the defendant sent 2 employees in a horse and cart to deliver some wine, and on the way back, the 2 employees went on a diversion in order to do some business of their own. They were on a frolic of their own. And while doing this particular task, the claimant was run over owing to the negligence of the employee who was driving the horse and cart. And it was held that the defendant was not liable for the negligence of his employee because the employee was on a frolic, he'd gone on a diversion of his own, he wasn't actually in the course of employment at that time. But an employer will be vicariously liable for the torts of his employee if the employee is doing an act authorised by the employer, albeit if he's doing it in an unauthorised manner. And the case to look at here is Century Insurance and the Northern Ireland Road Transport Board. And in that particular case, a driver was employed by the defendant company to deliver petrol. And part of his job involved transferring petrol from his lorry to a storage tank at the destination. Now, while he was doing this, the employee decided he wanted to smoke. He lit a cigarette, threw the match to the ground and caused an explosion. And the defendant was held to be vicariously liable for his employee's conduct here, because although the employee's conduct was clearly careless and negligent, he was in the process of carrying out an authorised act, i.e. delivering the petrol, albeit he did it in an unauthorised or negligent manner. And if we consider explicitly prohibited acts, as you might expect, the courts normally deny vicarious liability claims when the employer has specifically prohibited their employee from taking a particular course of action. And a case you could discuss here is the case of Iqbal, and in that case a bus conductor was prohibited from driving. It was outside of the scope of his job, but nevertheless he decided to move a bus that was blocking a depot, and when he was doing that he crashed it, injuring another employee. But the court rejected the vicarious liability claim on the basis that the employee's conduct was beyond his duties. It was outside of the course of his employment because he had been expressly prohibited from driving. However, it gets a bit complicated when we get into unlawful activity, because we've got these cases here where our employees were doing unlawful acts that were clearly not wanted by the employer, like in the case of Iqbal. However, nonetheless, vicarious liability was found. So in the case of Lister, very unfortunate case, very unpleasant facts involving sexual abuse of children, but the court applied the test of closeness of connection to the situation and held that since the abuse occurred on the employer's premises whilst the employee was performing his duties of caring for the children, vicarious liability was imposed. And a similar decision was reached in the Catholic Child Welfare Society cases as well. So let's just conclude by looking at some of the key evaluative points of this area, because it is a bit of a controversial area of law. So you need to be prepared in your exam to discuss arguments in favour of this type of liability and also arguments against it. So the main arguments in favour of vicarious liability sort of stem from this old-fashioned phrase, the master has the deepest pockets, and that's what this money is symbolising here, in that the employer is generally in a better position to pay the damages caused to our claimant, and they might have insurance for that purpose as well. We could also say that having vicarious liability is going to encourage accident prevention. Employers, if they know that they might be liable for the torts of their employees, might be more likely to train their staff, take precautions, and things like that. So that's a positive. And what we said at the beginning with that quote from Lord Nichols was that as the employer makes a profit from the actions of employees, it's only fair he should also bear any losses that they cause him too. But the other side of the coin then, there are arguments against this type of liability, and you can see that it does seem harsh on employers who are liable despite not being at fault themselves. And of course they might have given lots of training to their staff and their employees, and the employees still do things negligently anyway, and that does seem harsh. We could also say that distinguishing between contracts of employment and contracts for services is difficult, and you could use the Farah and Uber case that you may have seen in my previous video on vicarious liability on that. And the fact that it's difficult to distinguish between these different types of contract might mean that employers don't even necessarily know where they stand in the eyes of the law, whether they will be held to be employers or not for the purposes of this tort. You could also talk about the cases that we ended on the previous slide, the case of Lister and the case of the Catholic Child Welfare Society. Those particular cases where employers are being held for the unlawful acts of their employees seem to conflict, seem to be inconsistent with the idea of retributive justice, because it seems wrong that a person can be found liable in tort when they've done nothing wrong, and they clearly didn't want that abuse, those unlawful actions to occur, and we saw that sort of conflicts with the other rule in vicarious liability, where generally employers are not liable for prohibited acts, like in the case of Iqbal. Well, clearly in Catholic Welfare Society, that goes against that rule, because those unlawful acts were clearly against what the employer wanted. So it does seem very harsh, but of course the other side of that is it does mean that our claimants are able to get compensation from the employers, who ultimately should be responsible for their employees. They hired them, so you could argue, you know, they need to be taking really close attention to who they're employing and to be responsible for any unlawful acts that happen during the course of the employment. So thanks for watching this revision video. I hope it's been helpful in providing a little refresher for you. Do remember that I do have other vicarious liability video tutorials that you can watch. You can see here I've just screenshot the vicarious liability playlist. You can see some model answers and examples of how to apply the law on vicarious liability. So do watch them as well. And if you wouldn't mind liking and subscribing to my channel, it really helps me to make new content. Thank you.